Great, thank you, Jane, and thank you to the two previous speakers for the excellent presentations, which I'll pick up on. I'm going to need the host to put my slides up. If that can happen, that would be great. Okay, thank you. And look more really at domestic regulatory objectives leading to an international agreement or at the WTO. Now, if we look at policy and regulatory objectives, actually both, they're really the same for the domestic sphere and the international sphere. What is it we're trying to get out of e-commerce or digital trade negotiations at an FTA or at the WTO? It's actually, I think, the same thing for most countries at a domestic level. We want to, and I'm going to use Jane's language here, allow the digital transformation to take place, right? We want regulation or we want a framework, but we don't want to block. We want it to go forward. We want to allow the transformation to take place. We want to facilitate the opportunities that come from cross-border data flow, and that's really what I will focus on today, is that cross-border flow of data, and we want to minimize the externalities. Now, while we have many countries and jurisdictions that have positions on this, and of course Pascal went over a number of them, the leading ones really would be the US, the EU, China, you have Russia, Indonesia, Singapore, others that follow. But a lot of countries and jurisdictions haven't really set the domestic framework yet. They haven't really figured out what's their own domestic imperative and how that fits into regional international links, which in fact they've already developed or are developing. And I think this is one of the reasons why a lot of countries have not signed up for the negotiations in Geneva. They recognize their own kind of infrastructure problems and lack of regulatory framework and don't really want to be bound by something that they're not really sure how it will affect them and their policy making. So just as an example here, I'll use my own jurisdiction of Hong Kong. There's no written policy. I don't think there's any unwritten policy either. And there's no legislative framework towards what Hong Kong would want for a policy on cross-border data or digital trade. Now, the imperatives from the domestic economy, though, are very clear. Economic drivers are the key to Hong Kong, right? It wants to be a fintech hub, it wants to be a global technology hub, and a financial corridor to and from China. These are actually written down in very clear economic imperatives. But when looking at what it must do to get there, part of that, of course, relates to cross-border trade, the impact of digital technologies, and in fact, the importance and strategic role data flows play. Now, this is not going to be the same, of course, for other countries in terms of what it is they want to become and what they want to consider. And this goes back to Hildegard's point. It's not one size fits all here, right? Different countries are going to have different drivers. It just so happens Hong Kong is obviously an economic entrepot to and from China and a free trade city. So in this regard, it's a very simple illustration here. If it wants to be a business hub, if it wants to be a technology hub, and if it wants to be a finance hub, what does it need to rely on in all three of those things? Data flows. So data flows are going to play and are playing a crucial role in the economic success of Hong Kong. Data flows are at the heart. Now, this is an incredibly complicated slide. It is my favorite slide ever, and I give credit to my research associate, Ron Yu, for putting it together for me, because I don't have the skills. But it's really quite instructive, and what it says is why formulate a policy and what do you need to look at? Now, at the core, you would say, are three things: national competitiveness, business attractiveness, and regulation. But then under that, it actually becomes incredibly complex, intertwined in the bottom layers of, well, we need to then consider trade and how this affects innovation and finance and safety and integrity, which is something, of course, Nihal will pick up on, and other issues. Now, it's that bottom layer then that gets to kind of the nitty gritty and policy making, which is okay if we're looking at national competitiveness and we're going to look at trade. What do we need to take into consideration? Well, it's the existing framework, the existing commitments, whether that be at the domestic level or at regional, bilateral, and international trade agreements. Obviously, intellectual property impacts upon innovation, which relates to really all three of those top layer points. Competition law, cybersecurity, privacy, consumer protection, etc., etc. So while I first really looked at this cross-border data issue from just the trade component, the more you look at it, the more complicated it gets. And in fact, you see that in order to remain competitive, you need to have a properly formulated policy. One misstep could lead to unintended consequences. I'll just give one example, well, two examples. One could be actually, some people would argue the EU's GDPR and its effect on investment and innovation within Europe. But a clear example would be Massachusetts in the US had a facial recognition. They wanted to ban facial recognition, which led to, in fact, an exodus of all the companies from Boston and Massachusetts that were working on those technologies. So that wasn't something that was anticipated. They didn't anticipate how is this going to affect the businesses that are here working on the new Silicon Valley in Massachusetts. Now, Hong Kong, as I said, has no clear policy or strategy, even though data is the driving force of the economy. But is there a by default policy due to trade agreements? Taking the wonderful Mira Burry's TEPT data set, which looks at PTAs concluded from 2000 to the early part of last year. What we see, just to basically very briefly in one sentence go over that, is obviously more and more agreements are dealing with e-commerce or digital trade, and in fact in a more comprehensive manner than before. Pascal went over a number of provisions in the USMCA, CPTPP, and others. So I won't go over there, but what we do see, though, I will say, is the leaders, the demandors, in terms of free trade agreements, and obviously the WTO initiative, have two things in common. They have a national policy and a strategic direction. And you have a number of other countries or jurisdictions which are taking, right? Which in an FTA, they will accept what is on offer, but they are not demanding. And in fact, it seems to me, sometimes don't even care what they are signing up to. Now, in the Hong Kong framework, I mean, this is great. We have a personal data privacy ordinance. There's one provision in that ordinance which is not in effect, which never came into effect because the business community did not like it. And that was the provision dealing with cross-border data flows. And it's a very EU-like provision, because essentially what it is saying is that you can't transfer data outside of Hong Kong unless the other regime you're transferring to has a substantially similar laws in place. And I mean, for obvious reasons, I think the Hong Kong business community did not like this, judging where most of their data, or a lot of it, is going. So this is not in force. It actually was an early law, but it never came into force. Now, contrast that to what Hong Kong is signing. I'll take the Australia-Hong Kong Free Trade Agreement as the example here, because it's Hong Kong's most comprehensive agreement. It looks very similar to the CPTPP, to the USMCA. It has some very strong provisions on there, banning localization of data, free flow of data, no customs duties, etc., etc. Now, this is it's interesting. Oh, the slide actually doesn't fit, unfortunately, because in the provisions there is, of course, a paragraph, subparagraph 3 of those articles are the exceptions, and the exception is to achieve a legitimate public purpose. and repeating Pascal's language, provided that it would not constitute a means of arbitrary or unjustifiable discrimination or disguised restriction on trade. This is, of course, a catch-all provision. What is a legitimate public policy objective? I think the trend, as we see both in trade and investment, is to really give wide scope to the government in that regard. So the question really is that going to undo a lot of the work that has been done? I think there's some problems with this by default policy as well. And I think two problems in particular in the Hong Kong context. One, I think, applies everywhere, which is actually, never mind. They both apply everywhere to every country, because the by default policy is not a coherent one, and it doesn't make for good policy. And I'll give you an example. That language, or those exception clauses, are in quite a number of Hong Kong's free trade agreements, but not all. So there's very little to, I would say, no safeguards in Hong Kong's agreement with ASEAN, Georgia, and Macau regarding flows even of financial data. Now, what this means is really Hong Kong's going to legislate to really the lowest level. They're not going to have a different legislative framework for different countries depending on the FTA. Administratively, that's going to be far too difficult. So if some contain safeguards and others don't, really they may just legislate without safeguards, which in fact we see Hong Kong doing in the IP context, particularly with pharmaceutical patents. The second thing is, if you look at the law, which is not in place, I think it's very much, as I said, resembles the European approach, but all of the FTAs that Hong Kong signs resemble the US approach. So we have, again, a bit of a disconnect as to which direction the jurisdiction is going. I'll just skip this slide, but it basically means the time is now. In fact, the time is yesterday to develop a policy, because so many initiatives are going on that it's very important to do so. Now, multilateral negotiations, a treaty whose time has come. I was a little surprised to see some skepticism by Hildegard and Pascal. I thought I was going to be the only skeptic, but in fact, it's a merry band of skeptics in some regard. And what I see the problem being is, I think the plurilateral agreements that are most successful, and in fact the agreements that are most successful, essentially codify standards that have been adopted by leaders. They don't really shoot us forward. Not many countries want that to happen. If they can codify common positions, that is great. Now, my worry is, because we have differing levels of different policy frameworks and approaches to issues that Pascal went over very, very clearly, is we might get what I would say is like an ACTA 2.0 emerge. The Anti-Counterfeiting Trade Agreement. If you remember that agreement, it's never came into force. Its purpose was to stop counterfeiting in intellectual property. And in fact, the objective was the international framework doesn't go far enough. We need to go further. The problem is no one wanted to change their law. So we ended up with an agreement which allowed every country to keep their laws in place. Switzerland, EU, US, Japan, no one had to change. Now, how can you actually improve the situation if no one has to change anything? And so my worry here is we get an agreement where consensus is reached, allowing each country to keep doing what they're doing. And in that sense, again, what's the purpose? What is actually the purpose? There may be some. If there's questions I can go into, that actually might have value in itself, but it's not going to, it may in fact harm efforts to allow the digital transformation to take place. The second worry, as I highlighted, is this very widely drafted public policy exceptions. Depending on interpretations, this could also, of course, undo some of our good work. So I do not want really countries to sign up knowing, well, it's okay because we have these exceptions, right? We see it in financial services now, with countries saying, well, that's all right that we signed up to commitments because there's this prudential clause, which means we can do what we want. Well, if you're signing an agreement with that mindset, it's probably not the best place to be. So I will stop there. Thank you for your attention, and I look forward to the discussion coming up after Nihal's presentation.